my name is Mark McLaughlin, and I'd like to talk to you today about inheritance tax and business property relief, and a particular point regarding business premises where these are owned outside of a family company, say, by one of the shareholders in the company. Now, relief is available for premises even though they're outside of the company, but the rate of relief is only 50%, and there are certain conditions which need to be satisfied. The first of those conditions is that the premises must be used wholly or mainly for the purposes of the business of a company of which the transferor then had control. Secondly, the company's shares must themselves be relevant business property for BPR purposes at that time. So going back to the first condition, what does control actually mean in this context? The legislation on control in the Inheritance Tax Act, it refers to control of powers of voting and a majority of votes capable of being exercised on them. Now, this doesn't necessarily mean that having more votes than anybody else will satisfy that condition. In a case called Warding and Others versus IRC, the taxpayer held 45% of the shares, which was more shares than any other shareholder held. But unfortunately, that wasn't sufficient to get her over the control test. The taxpayer's personal representatives argued in that case that the deceased's grandson, who was 4 years old, held 24% of the shares. And because he wasn't able to vote, that she effectively had a majority of the voting rights. But unfortunately, that argument didn't work. Another point to consider is what happens if you have a 50-50 company. So the shareholder owning the premises owns 50% of the shares. The other 50% may be owned by one or more other shareholders. What happens in those circumstances? Well, for the purposes of control, if the 50% shareholder with the premises also has a casting vote, then that will be sufficient to give them control and will give them effectively entitlement to business property relief on the transfer of the premises. There is a case on that, Walker's Executors versus IRC, which dealt with the casting vote question. Another point to consider is that you may have a situation where the shareholder owns 30% and his wife or civil partners, for example, may own the other 30%, so it's 60%. That would give them voting control together, and the legislation does allow them to do that. It's called the related property rule, and it does allow shares of spouses or civil partners to be combined. So that is quite a useful rule to bear in mind. Now, there is a potential pitfall, where the shareholder is making a gift of shares and the gift of the premises, and the key is to get the order right. So if the shareholder is making a gift of the shares, then it's important to make sure that that gift doesn't result in them losing control of the voting power in the company, because if that's followed by a gift of the premises, then the control condition won't be satisfied and BPR will be lost. Now, as I say, the aggregation of spouses or civil partners shareholdings, that may get them over the line, but as I say, care needs to be taken on that point. If it's already happened, so they've given away the shares, lost voting control, and then given away the premises, all is not necessarily lost, because if it's a gift to another individual, then that gift will be a potentially exempt transfer, which means that as long as the donor survives at least 7 years after making the gift will be exempt in any event, so it won't be necessary to consider the BPR conditions in those circumstances. I hope you found that useful. My name is Mark McLaughlin, and thank you for watching.